some biscuits.
Well, I'll tell you, we got a tiger by the tail with an issue like this. Before I introduce our guest speaker tonight, I was just wanting to highlight a couple of my own observations and experiences with this whole issue. I'm not going to tell you the whole history and the story of Elijah Elieff and what happened to him before an Ontario Human Rights Commission Board of Inquiry.
I guess in a nutshell, we had a fellow who owned some buildings, who had tenants in the buildings. They were not these were not top-end buildings in the city. And as time went by, they fell into a state of disrepair for reasons which are still being disputed. Reverend Susan Eagle got involved in some other community activists, seeking, they say, to protect the tenants' rights, to make sure the tenants were taken care of, and that led to a nose-to-nose battle with the landlord, Mr. Elieff.
Back in 1989, Mr. Elieff was trying to tell the public and tell the authorities that he needed help cleaning up his buildings, and he thought maybe because he believed that the tenants were not being instructed properly about how to keep the place clean. They were new immigrants to the country, fresh over from Vietnam and Cambodia, and areas where they were just not used to our style of living here. Susan Eagle got involved in 1989, and of course, and it became a public issue. What was going on in the background is that Susan Eagle was lobbying for government money for co-op housing, and that she and the United Church of Canada, who employed her to do this work, basically wanted to take those buildings that Mr. Elieff owned and convert them into government-sponsored co-op housing.
But if there was a problem with them, if he was unable to maintain them and had problems perhaps relating to the tenants, would that necessarily have been such a bad thing?
Well, he didn't really have the problems until Susan Eagle got involved. That Susan Eagle wanted these buildings for co-op public housing, so that the objective was to drive the value of the buildings down.
I went back into some of the files and looked at some of the stories, and there were stories about sewers backing up and sewage in the basement of these buildings that wasn't attended to in an appropriate manner, shall we say, in a prompt manner.
Well, these things were attended to, but 5 minutes after they were attended to, the problem came up again. And I remember during the hearings, I got to look at all the evidence. I still have a lot of this evidence in my possession. And I would see like an invoice from Salmon Plumbing and Heating, where the plumber made a comment on the side of the invoice that said, "No sewer is made to take these kinds of objects." And he listed all the objects that were being shoved down the sewer. Now, there's no reason that anybody would put that down there. There was an uncontrollable activity going on that property where people were actually vandalizing and making mess. Now, the problem was Mr. Elieff couldn't identify a single individual who broke a particular window, and therefore it always came down to, well, you know, can you prove it? Can you tell us who did it? Other tenants testified that they saw the children of some of the tenants, you know, breaking windows and doing things like that, but that doesn't make a case. And yet, so here's Mr. Elieff running to the authorities in the hope that they will help him rectify the problem. Instead, he finds out he is the victim of the law, and that the law goes after him, not after the tenants.
So I did go through those buildings in the early 1990s. And it went through some empty apartments where people had moved out, according to Mr. Elieff, and I have no reason to doubt him, in the middle of the night or left with rent unpaid, and had trashed them, smashed the sinks, broken the toilets, filled the bath, not filled, but excrement in the bathtubs, holes kicked and punched in the walls, doors kicked open, and so on. So there's no question in my mind that there was real damage being done out there by someone. But I want to move along a little bit to one of the things that seemed to overshadow all the rest of it, and that was the claims that Mr. Elieff was a racist. He said, no, I'm not a racist. I'm not prejudiced against these people.
Well, I looked at the evidence, and I would conclude without a doubt that there was no racist comment. I mean, the original comment was made in a November 1989 London Free Press article written by Greg Van Moorsel. And in that article, Mr. Elieff was explaining to him who he felt was responsible for the mess and vandalism at his apartments, and he said it was his tenants. And he said this, and he also made the infamous little pigs argument, where he was talking about the children there. He says they're like little pigs living in the jungle. They're making a mess, you know, and this was how he expressed it in his broken English. But never once did he make a racial reference, nor did he imply that it was all one race making the mess. However, you know, the Free Press took one look at him. He was white. They took a look at the majority of tenants. They're Asian, and therefore that was a racist comment. Even though the word Asian was not even mentioned by Mr. Elieff at any time.
How did it get to be such a big element of the story?
Because Susan Eagle pushed it, and she kept pushing it, and the London Free Press supported her, and it became the issue. Like, this is the big racism issue. Before the time Eagle took over, we were talking about, you know, I mentioned that Elieff always paid his bills. I had all his PUC bills right up to the point that Eagle got involved, and they were always generally paid up to date. I told him about the testimonies of all the tenants, how they all liked him and thought he was a good landlord.
They all liked him?
Well, pretty well, yeah, all of them. The ones that testified, there wasn't, no tenant got up to say anything against Mr. Elieff at any time except the tenant in question, who was Chip Ang Hom, and she was recruited by Susan Eagle and some city councilors at the time. You know, in late 1992, Susan Eagle started collecting his rent without permission from any court or any authority whatsoever. She started collecting his rent money. January 1st, 93, he defaults on his mortgage. Later in 93, Susan Eagle got permission from a judge retroactively to collect those rents. Now, you got to picture the landlord's position during that period. What is he to do? He doesn't even have the right to his rents. He doesn't know what his ownership status is with the buildings. You know, and that's the period where all the deterioration started happening. And subsequently, when the National Bank of Canada wouldn't take over the buildings, that's mostly the period that you're hearing about with the deterioration of the buildings. So on the last Friday of testimony, Susan Eagle got up in front of the courtroom and she testified that she still had $4,000 of Mr. Elieff's money in an account on which she is the sole signatory, set up purportedly to be a trust account for the tenants, and yet they have no signing authority or any say on this money. And for 10 years, both Elijah Elieff and Mr. Sergatis have been requesting an accounting of this money because it was supposed to be considered in the final arbitration.
Sergatis is the current owner.
He's the current owner, and nothing was made known then. It wasn't until that day of testimony that Mr. Elieff even knew that she still had any of his money. And he suffered quite badly over this.
Because we've already put all that in print for you. You've seen it in the mailer that went out. We had hoped that by tonight we would have a copy of our newsletter alert uncovering the hidden agendas behind Ontario's Human Rights Commission available by tonight. But we're going to have to mail it out to you later this week when it is ready, because it's not ready for two reasons tonight. One reason is I just didn't have enough time to get it there. We got about 36 of the 44 pages of this newsletter ready already, and we're at 44 pages and possibly counting. But also because over the next week, given the lack of media coverage that this issue engenders, we did invite all the media here tonight. I noticed that basically nobody showed up, which is one of the problems we've always had with this issue. But come this next week on Wednesday, I have a deadline to have a 1,400-word article into Scene magazine. And they will be featuring Elijah on their front page, and the center spread in this newspaper will be about Elijah's story. Most of you folks who are from out of town, I know some of you are from out of town here. Scene magazine is basically London's entertainment magazine. It's sort of Toronto's version of Now, only not quite as racy in some ways. In fact, this week's issue has an article in it, Government 101, a crash course. This is about us and something that they discovered in our literature. If you get a copy of the one that's out this week, get a few chuckles out of it. It's a little bit of humor there. But nevertheless, Elijah will be on the front cover of this magazine next week, and then we're hoping that with that being distributed to the city, maybe some of the other media might go, oh, how did we ignore this story? Maybe we'd better say something about this. When I first met Elijah, our guest of honor tonight here, way back in 1991, 92, I guess, I just went as an observer to see him trying to defend himself before a board of inquiry. Absolutely having no clue, really, as to what he was defending himself against. He thought he would just go in there and present the facts, and the judge would look at the facts and say, well, of course, Mr. Elieff, you can't possibly be guilty of what you're being accused of. And after 2 days of sitting as an observer, I realized that there was something else going on beyond the charges that were being levied against this person, and that he didn't really know what the overall plan was. So, silly me, I volunteered to represent him for the balance of the hearings, which stretched out for about another 2 years. And we spent a good 9 full days before a board of inquiry. And that's on top of that, you can add the 2 days that he spent on his own. 13. Oh, 13. And to give you some idea of what you're up against here, I just brought along with me here. This is a sample of the transcripts that they're recording. Now, we photocopied them double-sided, you know, if you normally get these. This is 5 days worth of transcripts. This is another 5 days worth of transcripts, which I'll just put over here if anybody wants to look at them later. All over an alleged little comment that was printed in the paper. We have as well here a binder that has a lot of legal documents concerning the current issue, and this is nothing but London Free Press newspaper articles that lent what they call the notoriety to the issue, which was so important to make this issue so important to the Human Rights Commission. And I'm going to leave these around too if anybody wants to look at them after our event this evening. Feel free to. And by the way, anytime you want to know any of the facts or see any of the original documents, we will be happy to provide them. But back at the office, I have another 2 full filing cabinets full of, quote, evidence relating to all kinds of nonsense and statistical reports that they brought in. But, of course, what we discovered when we got involved in the case was, after putting all that together, it reads like a book. You get all those London Free Press articles and you put them together over a 10-year period, and it tells you the story. These buildings were targeted for co-op housing, that the people who are after them are going to use every single legal means at their disposal to get at them, including laying charges before the Human Rights Commission. Elijah is not the only person that this has happened to. This is happening to all kinds of people. We have another gentleman sitting here right at the table in front of us, Mr. Andrew Falvey, if you just want to raise your hand, Andrew. Andrew has had the same problem in the Sarnia area, where he's lost a lot of his property, and he was the subject of a W5 documentary talking about the whole co-op housing scam that was going on there. The Harris government has been trying to do something about the co-op housing issue in the Toronto area, and I personally went and met with several members of his cabinet there to discuss this one-on-one. Although I don't know that anything really productive came out of it, but they certainly are aware of this situation. Now, I was lucky in as much as I was not a lawyer, and when we went for our first round and went through the Board of Inquiry process, we did basically win our case. And unfortunately, after a couple of years, the Human Rights Commission appealed and took it to the divisional court, where they overturned that decision, or so they say. What really bothered me about the 19-page appeal that Mr. Elieff lost was that in the 19 pages, not even one word was expressed in terms of what his side of the story was. They didn't speak to any of the facts. They didn't speak to any of the situations surrounding it. They spent half of the document talking about whether interest could be charged on fines levied in the past, and the other half on some other legal stuff. So it's a pretty scary situation when you can give people the facts and they're not interested in the facts anymore. What they're interested in is the law and the way that they can apply the law and bend the facts any way they want. It certainly was an interesting experience for me because over time, as we went through the process, we actually had one of our issues of Freedom Flyer banned by the Ontario Human Rights Commission. And retroactively, too, because we had already distributed it and mailed it out. And what this issue contained was a paragraph relating to the deal that they wanted to make with Elijah that they would have accepted if he had only said he was guilty, but he refused to do so. And while they would have settled it first for just a simple apology and a month or two free rent for the complainant. But because he said he wasn't guilty, they threw the book at him. And I was not allowed to bring this fact up in court. They were going after like hundreds of thousands of dollars worth of damages and all kinds of fines. They even wanted him and his family to go to anti-racism classes. And I was going to bring up the issue, well, if you're willing to settle for an apology and a month's free rent, how can you justify these exorbitant consequences? Well, boy, that was the first time I got yelled at by the judge. I wasn't allowed to bring that kind of a thing up. And unfortunately, I'd already published this in Freedom Flyer, and we will publish it again in our upcoming issue of Alert. But it just gives you some idea of what kind of an issue this really is. It's really ironic too, because over the years there's been a lot written of this. I remember when Jeff Schlemmer, who by the way is a lawyer who runs with Neighborhood Legal Services, and which is one of the named people in the suit, when he originally had this article that you saw in your mailer published back in October 1st, this is 1994. The first time I ever spoke to the man was the day that this was published, and I was threatening to sue him for all the lies that I said were in it. And as irony would point out, I mean, this is the guy I shared the show Left, Right, and Center with for the past 2.5 years, so that was the second time we met after I had that particular meeting with him. And of course, I've also had the occasion to debate Susan Eagle as well on Left, Right, and Center, as she came in occasionally to be a pitch hitter for anyone who couldn't make it. But certainly, the whole issue is not going to go away for quite some time. This is going to be a lengthy battle. The dinner we're having here tonight is the first of the series. 2 weeks from tonight, Rory and I and Elijah will be in Toronto at another similar event, not hosted by Freedom Party this time, but hosted by Voice of Canadians in Toronto, who are organizing a meeting as well. They heard about our story, and they're trying to get people in the Toronto area interested and in supporting Elijah's case. The papers were already filed about a year ago, and how many years do you think this could take, Tony, just off the top of your head?
Well, at least one more.
At least another year before we get into a courtroom, because we're still basically in the discovery stage, I guess. We will certainly update you in the pages of Freedom Flyer and our newsletters as this issue progresses. The proceeds of tonight's dinner are going half and half between ourselves and Elijah in terms of any money we make from this dinner. His will go towards legal fees. Ours will go towards our work to continue to publicize this and get more people involved. This is just the first salvo in a series of fundraisers that will take not just the form of dinners, but of publications, speaking, and hopefully some opportunities in the media. There's no issue bigger than this these days. Affirmative action, political correctness, and all the various accusations of racism. I find that our representatives, whether here or in Toronto on various TV shows, this is the one issue they get us to get on the air with, because we're the only ones brave enough to say anything opposite to the prevailing intellectual atmosphere that's out there. So that's the Cheyenne Court Challenge. As far as our guest speaker tonight, Rory Leishman, I don't know if he remembers this, but we first met back in May of 1984, sort of on a formal basis, at UWO at Huron College, where we were on the same side of a debating team. I don't know if you remember this, Rory, at the United Nations Association of Canada, and we were debating free trade versus foreign aid. And Rory and I were on one side, and I forget who was on the other side, but one of the gentlemen was an NDPer, and I forget who the other one was. That's how long ago it was, 1984. But it was an accidental meeting, really, because I wasn't supposed to even be there that night. He was going to be teamed up with Mark Emery, but Mark got sick the night before. And I figured anybody who's brave enough to get on a stage with Mark has got to be good in my books. But as time went on, Rory was one of the few people at the London Free Press who kept tabs on this issue and gave a little bit of the spin to our direction. I will never forget the day after our first victory and before the Human Rights, or before the tribunal. Rory called me, I think it was 2:43 in the afternoon, and he was the only person from the media public who ever called me up and said, "Thank you." He said, "Thank you for defending Mr. Elieff before the Human Rights Commission." And this just blew me away, because I was already on my down from the whole experience. And so tonight, what I'd like to do is say thank you to Rory. And with that in mind, Rory, if you'll just get up here for a sec, I just got a little something for you. And this is one of our Freedom 200 pins, just like the pin I'm wearing, with the old logo of Freedom Party on a Canadian leaf and the Ontario Trillium in it. There are only 200 of these in existence. We haven't given them all out yet. But if you ever want to wear this and be politically incorrect and stuck in people around most of you know Rory from the London Free Press locally, from his columns. He's been basically called the only, quote, right-winger at the Free Press for probably a decade or two. You'll see his columns now also in papers like the National Post. He's been a long-time opposition to quasi-judicial bodies like the Human Rights Commission. And among the few in the media who recognize the dangers of these commissions and actually dares to speak out against it. He wants to see human rights commissions abolished, and so do we.
Yeah, right.
And that's why I bring you tonight, Mr. Rory Leishman.
Well, thank you very much, Robert. I much appreciate that introduction. If you don't mind, I'll take a little while before I put that pin on, because as a journalist, of course, I'm strictly nonpartisan. And I also hasten to add that, I come here really for two reasons tonight. Like all of you, and I'm most appreciative that you're all here, paying $50 to contribute to Freedom Party and find dinner and to help Mr. Elieff with his legal expenses. So I'm very pleased to come here to do a little bit to promote this just cause myself. And I had a second reason to come, and that was to pay tribute to Bob Metz. And I've just heard him praise me as a fine journalist at the Free Press. And I often hear people say, Rory, you're the finest journalist in the Free Press. And I say, is there one other journalist you like in the Free Press? Often stumped with that question. But I was very impressed at the time, and I still am, with the hours, the days that you put in helping Mr. Elieff before that Human Rights Commission. That you are one of the few that understand that when one person's rights are being jeopardized, when one person is brought before a process without representation, when his rights can be jeopardized in that way, then the rights of all of us are in jeopardy. And so that's why I was most delighted, most pleased, and really most grateful that for the contribution that you've made to defending Mr. Elieff. One thing that they say about Bob, though, that I want to affirm right off the bat, that we don't agree about everything. I say that to protect Bob's reputation. Make that clear at the beginning. But one thing that we do, as Bob mentioned, are in wholehearted agreement on, and that is the grave dangers that are posed to freedom under the law in Canada by these human rights commissions. They're misnamed. They're not human rights commissions in any meaningful sense of the term. They're human rights suppression commissions. They're freedom suppression commissions. Most of our fellow Canadians are completely asleep at the switch. They don't understand it. They think that we're still living essentially in a country where they are secure in their freedom under law. And I would suggest that so long as someone like Mr. Elieff or you can have your rights trampled upon, none of us can be secure. Now, Bob is the preeminent expert on the Elieff case, so journalists, their ego knows no bounds, but practically. But I know that there's no, I'll leave it to him to talk on that issue. In fact, Bob has asked me to address other cases that illustrate the perils that are opposed by human rights commissions to our freedom in Canada. Cases, there are any number that you can, that I could cite of how our freedoms, individual freedoms, have been circumscribed, quashed by human rights commissions. One, for example, would be the Blaney versus the Ontario Hockey Association. So a few years ago, a case that came before the Board of Inquiry of the Ontario Human Rights Commission You may remember Justine Blaney was the young hockey player, very talented young hockey player that wanted to play in an all-boys league that they had at that time in Toronto. That was run by the Ontario Hockey Association. They said, well, no, we just want boys in our league, so we don't admit girls. She went to the Ontario Human Rights Commission. They took her case, and a board of inquiry ruled in that case that the Ontario Hockey Association cannot discriminate on the basis of sex when it comes to admitting girls into the league. But in the same case, they argued that the Ontario Women's Hockey League can discriminate against boys when it comes to boys applying to play in their league, because boys are not, unlike girls, are not disadvantaged when it comes to playing hockey. There are all sorts of contradictions of that kind that one can cite, and you wonder whatever happened to the idea of freedom of association in Canada? What about the right of boys freely to associate with other boys if that's what they prefer to do, to play hockey? That right was always respected in Canada down until we had this Human Rights Commission decree. Umberto versus Vicentini Coiffure, another one in 1981. In this case, the owners of a hairdressing shop refused to hire Mr. Umberto because they felt that their female clients would prefer to be treated by female hairdressers. So he went to the Ontario Human Rights Commission. In this case, they said that the hairdressing shop cannot discriminate on the basis of sex. They must hire Mr. Umberto. They cannot discriminate against him. In fact, said he had a right to be employed in their hairdressing shop. Employers no longer are allowed to decide to set up a hairdressing shop or any kind of shop that is staffed entirely by women. I was reading the other day in PC Magazine, they had a little ad in there, a PC online distribution service, a computer and software purchasing service, and it's very proudly emblazoned on the top. It says, "We are the largest all-female only owned and managed firm in the state of Wisconsin." Wouldn't be allowed here in Ontario. Well, what about freedom of thought? That's freedom of association. What about freedom of thought, belief, opinion, and expression? I'm going to cite to you in this a case that is now underway in the province of Saskatchewan. And the prime culprits in this case are the Saskatchewan Human Rights Commission and the former Attorney General and Justice Minister in the Roy Romanow government, Mr. John Nielsen, QC. Together, Mr. Nielsen and the Saskatchewan Human Rights Commission dragged Hugh Owens, a former Christian Heritage Party candidate in Saskatchewan, and Lyle Sinkowitz, the publisher of the Saskatoon Star-Phoenix, before a board of inquiry on charges of discriminating on the basis of sexual orientation contrary to the Saskatchewan Human Rights Code. And the nature of the alleged offense was that Mr. Owens took out an ad in the Saskatoon Star-Phoenix that consisted entirely of biblical quotations proscribing the practice of homosexuality, and stick figures of two men holding hands with a circle and a red slash through it, the universal symbol of something forbidden. That's entirely what the ad consisted of, biblical quotations and that symbol. Well, the day after that ad appeared, there was a demonstration. The paper said there were 76 people demonstrating in front of the Star of Phoenix. They were upset. This was an attack on gay and lesbians in the province. And 3 self-avowed gay men complained to the Saskatchewan Human Rights Commission. And in their letter of complaint to the commission, they said that that publication of that advertisement alone, quote, tends to restrict the enjoyment of rights. Each of them said this on their letter, tends to restrict the enjoyment of rights which I am entitled to under the law, and exposes me to hatred and otherwise affronts my dignity because of my sexual orientation, contrary to Section 14 of the Saskatchewan Human Rights Code. Well, if you check the Saskatchewan Human Rights Code, you'll find that it says, in part, I won't quote the whole thing, but these are the relevant sections, no person shall publish or cause to be published through a television or radio broadcasting station or in any printed publication, any statement or other representation which belittles or otherwise affronts the dignity of any person or group of persons because of his or their race, creed, religion, color, sex, sexual orientation, family status, marital status, disability, age, nationality, ancestry, place of origin, or receipt of public assistance. Got that? You can't say anything in public that belittles anyone on any one of those bases. So theoretically, if you went on a radio station in Regina and told a goofy joke, you could be hauled before the Human Rights Commission because you have violated that section of the code. Whatever happened to freedom of expression in the province of Saskatchewan? People in many provinces might well be asking that question. In the British Columbia, there was a case involving Hunky Bill's House of Pierogies. Someone took the owner of Hunky Bill's before the British Columbia Human Rights Commission on charges that the name of his restaurant offended Ukrainians. The manager of the restaurant was dumbfounded because his name is William Connick and he himself is Ukrainian. Now, in the case of Owens and the Saskatoon Star-Phoenix, Mr. Nelson, QC, the lawyer, as Justice Minister, he has authority under the Saskatchewan Human Rights Code to refuse to hold a board of inquiry. The Human Rights Commission goes to him. They say the Human Rights Commission itself could have said this is frivolous, this is vexatious. There's no way that we're in the business of censoring Bible verses in a newspaper, or let alone stick figures. They could have said that and dismissed it. Oh, we're going to press ahead with this. We want to, because Mr. Owens and Mr. Sinkowitz both refused to back down, they went to Mr. Nelson and requested him to appoint a board of inquiry to look into this matter, to hold the kind of process that Mr. Elieff went through here in Ontario. Mr. Nelson, as Justice Minister, himself going to say, hey, we didn't pass that law in the legislature here to suppress freedom of the press. No way am I going to appoint that board of inquiry. No, he said, I think you got a case, and he agreed. He set up the board of inquiry to look into this matter. Now, if you were to ask Mr. Sinkowitz, what about freedom of expression in the province of Saskatchewan, he would say, oh, it's perfectly safe. It's not under attack from the Saskatchewan Human Rights Code. After all, Section 5 of our code states the following. Every person and every class of persons shall, under the law, enjoy the right to freedom of expression through all means of communication, including, without limiting the generality of the foregoing, the arts, speech, the press, or radio, television, or any other broadcasting device. We defend freedom of expression right in the code. And he can go on and say in Section 14, Section 14.1 says you're not allowed to say anything that belittles people in 14 different grounds. Section 14.2 of that same section says nothing in subsection 1 restricts the right to freedom of speech under the law upon any subject. Well, remember George Orwell in 1984 said that Big Brother would compel his subjects to practice doublethink. The art of holding two contradictory ideas in your mind and believing simultaneously that both of them are true. I submit that what we have in our human rights codes, there are similar provisions in the Ontario Human Rights Code and others. What we have here is doublethink enacted into law. That if subsection 1 says that you can suppress the expression of statements that belittle or upset people on 14 different grounds, if that's operative, then the guarantee of freedom of expression in subsection 2 is meaningless. It's a logical contradiction to say that both are meaningful at the same time when they're expressed in such very broad and sweeping language. Well, which is it? Which section does prevail? I think Nelson has tipped his hand. It's subsection 1 because he authorized the holding of that board of inquiry. Well, it met last August, and Mr. Sinkowitz, the publisher of the Star-Phoenix, was called to testify, and he said that he was absolutely dumbfounded that the Human Rights Commission would have taken this case and that the minister would have appointed a board of inquiry to look into it because for starters, he said, quote, in that the Bible is the best-selling book in the world and it is generally not thought to be hate literature, I thought it was okay to run the ad, end quote. Sienkiewicz also told the board that the Star Phoenix does not discriminate on the basis of sexual orientation. And they had a reef of articles and letters to the editor, some written by gays themselves, in support of gay lifestyle and gay rights issues, and others opposed. He said, as a newspaper, it's our responsibility to see that all responsible sides of this debate are represented before the public. And, quote, homosexual rights and matters pertaining to homosexual rights are public issues. We have a responsibility to the public for public discussion, end quote. And he went on to say that freedom of speech is the most precious right in a democracy. By extension, freedom of press is the most precious right in a democracy. However, when Mr. Owens asked Mr. Sienkiewicz, would he mind running that ad again? He refused, because they had that demonstration of 76 people in front of the newspapers. Oh, gee, this is too controversial. What kind of commitment does that guy have to the most precious right in a democracy, I wonder? At any rate, under questioning from Darian Moore, a lawyer for the Saskatchewan Human Rights Commission, Mr. Sienkiewicz allowed that he would not have published upon request a picture of an Aboriginal person with a circle and red slash through superimposed on top of him. And Mr. Moore professed to be aghast, and he told the board that Sienkiewicz, quote, recognized that an Aboriginal person would be protected under the code. I find it quite amazing that he would publish the ad with a gay person when they are equally protected, end quote. Now, that Moore equates the practice of homosexuality with the color of somebody's skin. I find astonishing enough to begin with, but what's even more shocking is that he feels, as a lawyer and a representative of the Human Rights Commission, that the Commission, has a right to impose their moral views on this on everyone else in the province of Saskatchewan. Now, what do clerics think about this unprecedented attack upon freedom of conscience and religion? Some of them aren't the least bit upset. An Anglican chaplain at the University of Saskatchewan, the Reverend Canon Colin Clay, stated in testimony before the board that he felt that Mr. Owens' views, those Bible verses, should not be published in any respectable newspaper. Reverend Brent Hawks, who is the senior pastor of the Metropolitan Community Church of Toronto, advised the board that Roman Catholics and Orthodox Jews will be punished by God for insisting that the practice of homosexuality is a sin. Father Paul Dunleavy, a Roman Catholic priest, expressed a decidedly different view. He was called to testify on that same day, and he told the board, told them about several priests from Saskatoon that were serving on mission fields, in Africa. And he said, over in Africa, they have experienced government interference with their freedom of religion. And he said, he wondered how far suppression of freedom of religion might go in Canada. He said, quote, it is the role of religion to challenge the morals of society. So I'm not suggesting that our views on the practice are necessarily popular, that they are reflected by the majority, but surely we have a right in Canada to hold these views and to express them in a supposedly free and democratic country. Rabbi Steve Kaplan concurred with Father Dunleavy on this. He explained to the board that Jewish tradition condemns the gay lifestyle, but not gay people. He served notice, no one can tell me I can't express the tenets of my faith, end quote. Well, Mr. Owens, by the way, in his testimony before the board, expressed essentially concurrence with Father Dunleavy and Steve Kaplan that he abhors homophobia. He wants nothing to do with violence against homosexuals. And he thinks that people who commit violent acts, the people who violate the legal rights of homosexuals, the legal rights under the criminal code, should have the book thrown at them. But he also insists on his, as a Christian, that the practice of homosexuality is wrong and particularly dangerous in the middle of an AIDS epidemic, and insisted he should have a right to say that and to have that idea published at his own expense in a Saskatchewan newspaper. Well, the Board of Inquiry has yet to hand down its decision in this case. And meanwhile, in Ontario, there's a similar case involving Scott Brocky that many of you may recall. He's the print shop owner in Toronto, and he has been summoned to appear before an Ontario Board of Inquiry. In fact, already has appeared before such a board, on charges of violating the ban on discrimination on the basis of sexual orientation in the Ontario Human Rights Code, because he refused to publish material on behalf of a group called the Gay and Lesbian Archive. Scott Brocky, like Owens, is an evangelical Christian. He said in good conscience he could not publish that material, and invited the Gay and Lesbian Archive to go to any number of other print shops in the Mississauga area. I think it's Mississauga where his shop is, to have that done. But no, they went to the Ontario Human Rights Commission, and the Ontario Human Rights Commission fired off a letter to Mr. Brocky saying, look, you violated the code, but all you have to do is write out a check for $5,000 to the Gay and Lesbian Archive and apologize for your discrimination, and we'll just drop the whole thing. You won't have any problem. Mr. Brocky said nothing doing, and he's lost round one before the Board of Inquiry, and round two is scheduled to occur next week. Now, here in London, we know that it's not just what you say that can get you in trouble with the Ontario Human Rights Commission. What you refuse to say can embroil you in deep difficulties as well. Just ask Mayor Diane Haskell. She did not want to proclaim Gay Pride weekend for the city, and we know what happened to her. Mayor Haskell vowed, after she lost that hearing before the Board of Inquiry, that she would not bow down to the Ontario Human Rights Commission, that she would obey the dictates of her conscience. She would refuse to proclaim Gay Pride again, especially in the middle of an AIDS epidemic. She couldn't in good conscience do that, and she won't do it. Well, after she won overwhelming re-election in our last municipal election, the HALO, the Homophile Association of London, Ontario, decided it would be prudent not to exercise the authority that had been given to them by a Board of Inquiry tribunal to insist that the mayor issue this proclamation. They said, well, we'll have city council do it. And the city council, so many of whom had backed the mayor originally, many councillors they switched in time. This is so convenient to have a flexible conscience. And they issued the proclamation, so the mayor really is off the hook. Well, what about Scott Brocky? He has said, like the mayor, and he seems to be made of the same stern stuff, no way am I going to comply. No way will I apologize, let alone pay the $5,000 that the Human Rights Commission has suggested. What could happen to him? Michael Corrin, in a column in the London Free Press, wrote about this case, and he said that if Brocky is found guilty, he will be fined, and if he refuses to pay the fine, he could and probably will go to prison. His family and friends would naturally be devastated. End quote. Well, that column provoked a rebuttal from Ontario's chief human rights oppressor, commissioner, Keith Norton. And he said in that column, quote, I want to make it clear there is nothing in the process under the Ontario Human Rights Code that provides for a person going to prison. That could only happen in a subsequent proceeding if the individual were found to be in contempt of court. I know of no case in the 36-year history of human rights legislation where that has happened. End quote. Well, someone wrote a rebuttal, sir rebuttal to that one, and modesty forbids me to say who, who suggested that this was a very disingenuous statement from the Chief Commissioner, Keith Norton, because there is a precedent. Now, what he said there technically was correct. No one has yet gone to jail for violating or for refusing to obey an order of the Ontario Human Rights Commission as enforced by a tribunal of the courts. No one has gone to jail for that. But as Norton knows full well, a person did go to jail and serve time for refusing to bow down to the dictates of the Canadian Human Rights Tribunal. And Corin is absolutely right that if Scott Brocky does the same thing, he too could end up in the slammer. Now that person was a racist, as it happens, John Ross Taylor. But we're talking here is principle. We're not defending Taylor's obnoxious views, his despicable views. But what we're talking about is the threat to all of us posed by the draconian powers that have been conferred on these human rights commissions. My friend Ian Hunter is a professor emeritus at the law school at the University of Western Ontario, writes that brilliant column on Thursdays in the National Post. If you don't see it, I commend it to you. He has educated me on this subject, and I owe a lot to him for helping me to understand what has gone wrong. I hesitate to digress about how I originally welcomed the Charter of Rights and Freedoms, but have long rued and apologized and repented of that error of my youthful folly as a journalist. At any rate, he, in an article in the McGill Law Journal, back in 1983, Professor Hunter pointed out that human rights commissions initially were really quite benign. They had very limited powers. But then the Conservative government of Ontario granted it sweeping powers, essentially, and it's been modified since, but it was there in 1980 amendments that set up the human rights juggernaut that we're facing now. And he wrote in that article in the McGill Law Journal, the starkest example of the conflict between human rights and fundamental liberties in Canada occurred in 1979, when a Canadian Human Rights Tribunal concluded that the expressed opinions of John Ross Taylor were contrary to the letter and spirit of the Canadian Human Rights Act. And Mr. Taylor was ordered to cease recording and communicating his opinions by telephone. Carolyn wants me to get a breath. A swallow of water here for a second. Mr. Taylor, who was 69 years old, refused to alter either his opinions or his practices. He was then convicted of contempt of court and served 1 year in jail, thereby becoming Canada's first prisoner of conscience to be jailed for daring to contradict the orthodoxy of human rights. And Ian adds, it should be, but is not superfluous to point out to human rights commissions that one may defend John Ross Taylor's right to free speech without endorsing his views. He says it should be obvious or unnecessary, but it is necessary to point because he was attacked by human rights commissioners. You're a racist to defend that guy. So I'm not defending that guy. I'm talking about principles, fundamental principles of freedom under law that have been violated in his case. Now, Taylor was convicted for violating the prohibition in the Canadian Human Rights Act, much like the Saskatchewan one, against the expression of hatred or contempt in this case, for an individual or group based on race, national or ethnic origin, color, religion, age, sex, sexual orientation, marriage status, family status, disability, or conviction for when a pardon has been granted. That's the federal Canadian Human Rights Act. And again, consider the implications of that provision in the law. If you were to go on a local television show and express the opinion that it's irresponsible for young people to shack up prior to marriage, you're holding people in contempt on the basis of family status. You could get into trouble under this cause, possibly for quoting from the Catechism of the Roman Catholic Church. And if you don't believe me, you can ask Sarah McEachern. She's the editor of a Roman Catholic journal, The Orator, in Ottawa, who confessed in a radio interview on an Ottawa station that she subscribed to the Orthodox Roman Catholic position that the practice of homosexuality is intrinsically depraved. As a result of this statement, she was subjected to an investigation by the Hate Crimes Unit of the Ottawa Carleton Regional Police. And she told the Ottawa Citizen, quote, I never once thought that it would be a crime in Canada to simply state the teaching of the Roman Catholic Church, end quote. Well, as I say, Brocky could very well end up in jail if he stands firmly by his views. And, well, how many people think that it would be a good idea? Do you think that, you know, to protect that principle of freedom under law that serves to safeguard all of us, do you think that guy really should firmly refuse, like Mayor Haskett, to accede to a rule by the Board of Inquiry that he must apologize for that group? Well, I caution you about saying so in public, because it's an offense under Section 13 of the Ontario Human Rights Code to encourage anyone to practice discrimination contrary to any one of those grounds in Part 1. And we have in our Ontario Human Rights Codes also, you know, protection for freedom of speech. Yeah, but remember Orwell and doublethink. We don't know. You know, even if he doesn't end up in jail, Section 41, Mr. Elieff, sorry, is well acquainted with Section 41 of the Ontario Human Rights Code, which says that a board of inquiry can direct a guilty party, quote, to do anything that, in the opinion of the board, the party ought to do to achieve compliance with this act, both in respect of the complaint and in respect of future practices. Isn't that amazing? Imagine what Chairman Mao would have done with authority like that. If you can do anything. You can, you know, I'm surprised the commissioners, there are a lot of outwork, little red guard, you know, brainwashers around there. Maybe we should import them into Ontario so that, you know, it's been suggested, so the likes of me. Can you imagine them trying to re-educate Bob into a proper understanding? A politically correct understanding of just mind-boggling. These Canadian Human Rights Commissions were an invention of the 1960s. We didn't have them before that time. Before there were any Human Rights Commissions in this country and commissioners, we had an exemplary, we had one of the best records in the world for respect for genuine human rights and fundamental freedoms of Canada. That record was not unblemished. We all know that. We can easily think of cases in which you know, there were shameful violations of those fundamental principles, but no system is perfect. And the problem is that any attempt to achieve perfection by state decree, state imposition, any agency, be it a Human Rights Commission or anything else, that is set up with the express view of stamping out anything imperfection, that's a prescription for tyranny. The freedom of speech and freedom of association mean anything at all. They must include the freedom to sometimes say things and to sometimes exercise your freedom of association in a way in which you and I would say, we wouldn't do that. And when we see that, we have an obligation to speak out, say, I disagree with you, you shouldn't have said that, that's outrageous. I think it's absolutely wrong that you refuse to allow so-and-so into your group, stop doing it. But when you empower the state to intervene and say the state will stop you from doing it, that's a dangerous power that no agent of the state should be trusted with. Thomas Sowell, a political philosopher at Stanford University, I think has put the matter very well. He said, if you are free only when others think you are right, then you are not free at all. And he said that the government in a well-ordered democracy might set down rules for itself about hiring and non-discrimination. But in a free society, private individuals and groups should be free, says Sowell, to, quote, make their own decisions, without being second-guessed by political or legal authorities as to where those decisions are wise or foolish, noble or mean. The scope of those boundaries of immunity from public authority are the scope of people's rights. There is a process, this is a process conception of rights, the legal ability of people to carry on certain process without regard to the desirability of the particular results as judged by others. Now, democracy is based on the proposition that freedom includes the freedom to err, and that this freedom of government based on that principle is better than any other form of government, certainly far better than any tyrannical regime. Thomas Jefferson stated this well in his first inaugural address. Sometimes, he said, it is said that man cannot be trusted with the government of himself. Can he then be trusted with the government of others? Or have we found angels in the forms of kings to govern him? Let history answer this question. Now, I ask you, have we found angels in the forms of human rights commissions to, decide what is best for us in this society in Canada? Suggested that we have not. What we have in our human rights commissions are not human rights commissions. We have freedom suppression commissions, and they're endangering the very fundamental. They have undermined the very fundamental principles of freedom under law, and that all of us had better wake up in a hurry to the grave threat that this poses to the freedoms of each and every one of us. And I'd like to think that one of my fighting Irish ancestors was John Philpott Curran. He's the guy who said, it was in 1785 or something, the condition, he warned this, the condition upon which God hath given liberty to man is eternal vigilance, which condition, if he break, servitude is at once the consequence of his crime and the punishment of his guilt. Thanks very much.
Rory is willing to take any of your questions.
I'll thank you for letting me know about that. That reminds me of the chiropractor in town. Remember that case where a handicapped person, she was in a wheelchair, wanted services? Well, they targeted this guy because he had his office in his home. And there were steps leading up to the front door or into his office. Correct me if I got the details wrong on this. I'm doing this from memory. But she insisted that he had an obligation to treat her, and he agreed. Well, I'm sorry. I'll help you up the step. Oh, I want access, ramp up there or whatever, free access to your building. So I'll arrange with a colleague who has wheelchair accessible facilities to provide you with services. Great. No, I want you to do it. Went to the Human Rights Commission, and they ordered him to spend tens of thousands of dollars to change his home to accommodate that one person. I don't think that's really good for handicapped people, because that breeds resentment. And not to mention what it's done to the property rights of that chiropractor. Ivan?
Yeah. About a year ago, I read in the newspaper about a man that continually came into work drunk. They warned them, and finally they fired him. And the Human Rights Commission forced them to rehire him.
Well, that's true, because alcoholism is a disease, and you can't discriminate on the basis of a handicap, disease. The Sarnia, the Imperial Oil in Sarnia, had some very strict rules for employees in key positions. Operators who, if they made a mistake, could send some pretty noxious stuff into the St. Clair River or into the sky. And they insisted that if they're going to retain this position, they got extra pay for it, that they would have to submit to random drug checks. The Ontario Human Rights Commission says that's not permissible. That's going too far. Well, maybe the Human Rights Commission is right about that. I don't know, but who should be making that decision? That really is. Should the individual be free under the law? I mean, if Imperial Oil is going to be reckless, then by all means, take them to court and throw the book at them. That's the way our liability laws, our tort laws are well calculated, evolved over centuries to deal with situations like that. And I think it's just nuts that the Human Rights Commission would come in and second-guess management of what is the best safety procedure for that plant.
Well, I was going to add to that, Rory, in that one of the situations the Human Rights Commission can get other people to do their dirty work for them is that if you are my employer and I come to you and say so-and-so said something derogatory on the basis of whatever to me, you are now legally obligated to act on that. Because if you don't act, then I can go to the Human Rights Commission and you can be charged.
That's right.
So they put you in the position of being the enforcer.
Yeah.
So it comes around in a number of ways.
Yeah.
Rory, who are these people? You talk about tribunals. The definition itself
no one knows who they are. There are no names of these people. They come out with these outrageous decisions. Okay? Their names are not in the paper. They come under the umbrella tribunal. Okay? No one knows who they are. Nobody has elected them. Where do they come from? I know the power they have, and so do you, and so does everybody in this room. Who do these people think they are? And where do they come from?
Robert Martin, another law professor at Western, a great deal of admiration for as well, has done exemplary work in this area. He's addressed that question. And he pointed out that in the case of the mayor, for example, there was just one person on that board of inquiry, just one appointed person.
The same with Elijah.
And the same with Elijah. I think that's typical.
The divisional court had 3 people.
Yeah, the divisional court has 3. But, you know, when you're appearing before a court, the long-established rules to protect the independence and impartiality of the court don't have those kinds of protections for these board of inquiry tribunal officers. They're usually recruited from, they all have law degrees, as far as I know, they're members of the bar. But as Martin said, the human rights establishment in Toronto recruits their pals, like-minded people, and appoints them to the board, and they serve on one time. I say, well, it doesn't matter because you can appeal to the courts. But you know, it does matter. And you just look what happened to our mayor and what's happening to Scott Rocky. It's a matter that should be of very profound concern. These autocratic judges and human rights commissions don't care a fig for democracy. They are intent on imposing their ideology on the rest of us. And it's just simply, it's not right, it's not just, and it's totally incompatible with our parliamentary democratic traditions.
Roy, maybe I can ask a question in a broader sense. Maybe you and maybe some of your learned friends at the university, the law professors and whatnot, can ask why in Canada we do not have constitutionally protected laws regarding property rights. Seeing as being relevant that this is the 80th birthday of Pierre Elliott Trudeau, who brought in the Charter of Rights and Freedoms in 1982, removed property rights as a constitutionally protected human right from our Constitution. Maybe you can ask one of your learned friends why we have that oxymoron.
Yeah, well, I know that certainly Ian Hunter would tell you that that was really a profound mistake. As you know, they debated that in Parliament when they were discussing the Charter in 81. And that was voted down. And he said that, you know, John Locke, in his second treatise on government, is that property rights are really fundamental. They're essential to freedom under law. If you're not secure in your property, then your other rights are jeopardized as well. But because they voted it down because they felt that that would interfere with the government's ability to expropriate property for socialist purposes. And if Robert Metz were Prime Minister of Canada, that would never have happened. These things happen because we're asleep at the switch. We've forgotten about the historical underpinnings of our freedoms. And we've allowed these things to sail through, and now we're faced with the consequences.
Yeah. We know what the problem is. What is your solution to the problem? What do you foresee there? How we can change that?
Well, I think that, as I say, Bob and I don't agree on everything, and I know some of my opinions really grate on his nerves. But we absolutely agree on this, and I think the Freedom Party of Ontario is doing a terrific job of alerting the people of Ontario to these issues. And there are people within the Conservative Party caucus that there aren't enough of them. And I think, we've got to have really as Curran said, if the average person doesn't care about his freedom anymore, it'll quickly be lost. And we just got to wake people up. And, you're probably, as a political activist, know more than I do about how to go about that. I think one of the yeah, one of the most hopeful things that I think that has happened in Canada in recent years is Conrad Black buying Southern News. Now my left-wing pals are telling me this is terrible, you know, that he's going to start imposing his ideology on Canadian newspapers, but it was awfully lonely down there at the London Free Press for a long time. Said, Rory, how did you ever end up like that? Well, I mean, when I went down there, I was I once shocked my colleagues in the paper by recalling in a column that in 1976, I went door to door, knocking on doors, distributing flyers for the New Democratic Party. I have repented, please. And so I don't think, though, when I look back over the years, back to the 60s, that my thinking really has not changed that much. I mean, I've always had compassion for the underdog and for the needy. I've always felt that we have an obligation personally to give of our surpluses to the, through my church and through other charitable organizations to help the needy. And it took me a while to realize that state welfare, I don't go off on a tangent here now, does more harm than good. And that I was instructed I studied politics at Queen's University, and one of my lecturers was John Corey, one of the great constitutional lawyers of his time, and he just drummed into us, Blackwell's commentary on the laws of England and John Locke and the fundamental principles of freedom under law. And I was absolutely persuaded. I still am. And I'm just astonished at how the rights that were so secure at that time have been so seriously undermined in such a short period of time. Really quite frightening. Yeah. I mean, I get serious people now are saying that it's rapidly getting, Muggeridge predicted this, Malcolm Muggeridge, that in our society we're soon getting to the point where if you're going to have a church, if you're going to have upholding Orthodox, Jewish, or Christian morality, you're going to have to meet in the underground and communicate by samizdat.
Time for one or two more questions.
Is Suzanne Eagle an ordained minister of the United Church?
Yes, she is.
Yes.
And that's another thing that Carol and I have to repent of. We used to belong to that organization. There are many fine people still in the United Church who are Orthodox Christians, but this is a part of the problem. Like that Canon Clay that testified to the Saskatchewan board. These guys have conformed their thinking to the pattern of this world, the degraded pattern that prevails in our society today. They've betrayed the faith, in my judgment, and that is a large part of our problem. I'll end on that.
And as we wrap up, I just want to, just one final little observation. The whole issue of racism has gotten so far in political correctness that you can be charged with having racist opinions even if they're against yourself, which is really strange. I mean, Dr. Philip Rushton didn't put whites at the top of the list. And then there's a fellow here, John McKellar, who has started a group called Homosexuals Opposed to Pride Extremism, who himself is now before a Human Rights Commission for daring to say that the whole homosexual lobby is a left-wing lobby that's promoting socialism in the courts. And he himself is homosexual, and yet he can be accused of being prejudiced against homosexuals. This is how ridiculous it's gotten. So, anyways, with that thought in mind, we're going to wrap up for the evening. This coming week, we'll be mailing out our special issue of Alert to you. Please do tell your friends, tell your acquaintances. We need money for this cause. The Cheyenne Court Challenge will be around for many years to come, and if you can get anyone else involved, pass along the information to them, and hopefully that sometime down the road this may set a precedent that finally says to some of the political activists out there, listen, enough is enough. You cannot abuse the social system and our legal system to be able to achieve your own personal ends. So I thank you one and all, and we'll be around for a little while if you want to just stand around and mill around and have a few questions that you might want to ask one-on-one. Thank you, and we'll hope to see you again soon.
Thank you for having us.
Take that.